Hey guys, welcome back to the channel where we break down complex legal concepts into simple, relatable terms. Today, we'll explore a fundamental concept in contract law, the offer. This is a cornerstone of contractual agreements, and we'll examine it under both common law and under Singapore law. We'll also discuss how an offer differs from an invitation to treat and provide 3 examples to help illustrate the concept and conclude with a commentary on its practical significance. An offer is a clear and unequivocal expression of willingness by one party, known as the offeror, to enter into a contract with another person, known as an offeree, on specific terms. To result in a binding agreement, the offer must be communicated to the other party, the offeree, who then accepts the offer. Under common law, an offer must be definite, specific, and demonstrate an intention to be bound upon acceptance. In Singapore, these principles are largely similar, as the courts here often follow English precedents. However, there are some local nuances in application reflective of Singapore's unique commercial and legal landscape. Importantly, an offer can take many forms: verbal, written, or even implied by conduct, but it must be communicated clearly. This is where the distinction between an offer and an invitation to treat becomes critical. An invitation to treat is not an offer, but it's a preliminary step, an invitation to negotiate or invite others to make an offer. A good example is the display of goods in a store. When items are placed on shelves, it is not an offer to sell, but an invitation for customers to make an offer to purchase the goods at a stated price. This principle was established in the English case of Pharmaceutical Society of Great Britain and Boots, where the court held that the display of goods in a self-service store was merely an invitation to treat, not a binding offer. Similarly, advertisements are typically invitations to treat, allowing potential buyers to approach the seller to negotiate the terms. To better understand what constitutes an offer, let's look at 3 examples. First, imagine you are selling a car. You advertise it for $20,000 and state that the first person to transfer the money gets the car. This is a clear offer because it is specific, definite, and shows your intention to be bound by the terms upon acceptance. Second example, consider tenders in business contracts. When a construction company submits a bid of $1 million to build a shopping mall, the bid itself is an offer, as it demonstrates a definite intention to perform the specified work if accepted by the client. Third example, think about offering a reward for the return of a lost item. If you put up a poster stating that you will pay $500 to anyone who returns your missing dog, this constitutes an offer to the public. If someone returns the dog, they have accepted the offer through their actions, and you are legally bound to pay the reward. The concept of an offer is vital because it provides clarity and certainty needed for parties to understand their obligations and rights in an agreement. In Singapore, this is particularly important in a dynamic commercial environment where legal certainty fosters trust and confidence in transactions. The distinction between an offer and an invitation to treat prevents premature obligations and ensure fairness, safeguarding parties from unintended commitments. Real-life scenarios, from simply grocery purchases to complex business negotiations, revolve around the principles of an offer, making this concept highly relevant to everyone. A significant number of legal disputes arise due to miscommunications about whether an offer was made or accepted, especially in the context of email agreements or WhatsApp agreements or even oral agreements. This underscores the importance of ensuring clarity in your dealings, whether they involve verbal, formal contracts, or even casual exchanges. A solid understanding of what constitutes an offer empowers individuals and businesses alike to make better decisions to avoid unnecessary conflicts. That's all for today's discussion. Thanks for tuning in. See you in the next video.